First off, did you expect it to play out this way? Seeing the fact that the former governor had eventually turned himself in after taking so long, and then, of course, he's been told to, hold on while the EFCC still holds on to him until December 10. Were you expecting anything quite different? And as a lawyer, could you break down the terms of he has not pleaded guilty to the 16-count charge? We recall that it was from 19 all the way to 16. Can you expatiate more on this?
Okay. By Nigeria's criminal jurisprudential trajectory, a person that is alleged to have committed an offense can be arraigned in court by any of the prosecutorial authorities. In that regard, in this regard, really, we're talking about the Economic and Financial Crimes Commission. So what this means is that the EFCC, based on the powers it has to arraign alleged suspects in court, filed a charge against former Governor Yahaya Bello of Kogi State. The former governor himself has been in a cat and mouse game with the EFCC. He has not submitted himself to arraignment for a very long time. As we will speak, the case is presently in the Supreme Court as to the propriety otherwise of the procedure that has been adopted for his arraignment. But as you are aware, about 48 hours, the former governor submitted himself for arraignment, and that what we saw play out in the first city court started over by my noble lord, Honorable Justice Maryanne Anenih. And of course, there are always legalese when it comes to grant or refusal of bail. That is what you see play out. Of course, Section 36, subsection 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended by the 5th alteration, indicates that if any person that is alleged to have committed an offense is presumed to be innocent. So that is upon which you see people usually plead not guilty, to an offense, except they themselves concede to being guilty. So that is why you see former Governor Yahaya Bello pleaded not guilty to the allegations against him, the 16-count charge, like directly stated, reduced 16-count charges against him. And of course, there was a legal brickbats between counsel to the EFCC and PD Daudu and the counsel to Yahaya Bello, PD Daudu, and the EFCC, Kemi Pinheiro, who have been senior advocates of Nigeria. And the judge, based on that, in my Lord's wisdom, he adjourned the matter to the 10th of December 2024 for reading of the bail application. I want to clarify some issues based on what I want to call two things, first of all, and that no matter who you are, no matter how powerful you are, once you have been alleged to have committed an offense, it's just an allegation, you should submit yourself to arraignment. Even if you have to challenge the propriety or impropriety of the charges, you should be present in court. It's something that is incumbent on any person alleged to have committed offense to be present in court. Except, of course, the law allows that. And in that case, you have to be able to show to the court that the law allows that. Now, another thing is that once a person has submitted himself for arraignment in court, according to Section 158 of the Administration of Criminal Justice Act of Nigeria, and I need to read this because it is very important for us to situate what is happening right now. Section 158 of the Administration of Criminal Justice Act of Nigeria states, and I quote, in fact, the marginal note says general entitlements to bail. It says when a person is suspected to have committed an offense or is accused of an offense, is arrested or detained, or appears or is brought before a court, he shall, the underlying word being shall, subject to the provisions of the law, be entitled to bail. So what it means is that bail is an entitlement. I have argued in forums, a lot of fora, and I want to restate it, that bail, except it is one that is derogated by way of one that concerns capital offenses like murder, armed robbery, kidnapping, and the likes. For matters in which the Constitution and the law have stated, it is no longer within the discretion of the courts. It's an entitlement, it's a constitutional right. Once a person appears before the courts, it is only in Nigeria that somebody will leave his house, go to courts, and be remanded in prison custody. And the question I ask myself is, what is the legal sense? Or let's ask ourselves the question, what is the economic sense of remanding people in prison custody? This is without prejudice to what happened in Abuja yesterday. I'm not saying that the judge did wrong by remanding Governor Yahaya Bello in prison custody. As you know, Governor Yahaya Bello has been, he has been on the run. He has not submitted himself, to prosecution. So the judge, in my view, would have acted based on the facts of the case. But in other cases, it is my contention, and rightly so, following the provisions of the law, Section 36(6) of the Constitution, Section 35(4) of the Constitution, Section 27 of the Police Act, and Section 154 of the Administration of Criminal Justice Act, that any person that appears in court, he comes to court by himself. There is no reason you should remand that person.
Yeah, but let me just. I think everyone understands your argument, and these are things that must be fixed with regards, our criminal justice system, and that the way Nigeria functions generally. We see these flaws, but I think the peculiarity with this case, which you've also, mentioned, is the fact that the accused in this case had evaded, court multiple times, even while he was declared wanted, and very likely had his police orderlies. It's the peculiarity with the way Nigeria works. So it's not necessarily surprising to hear that, for whatever reason they chose yesterday, it's not necessarily surprising to see that, yes, if he was granted bail, we may never see him again, in court, if he decides to, once again continue to evade a trial. I think, but aside this case, we all agree that our criminal justice system needs to be fixed in a way that if a person is arrested, can be granted bail, knowing that if he jumps bail, he will be arrested, regardless of how highly placed that person is. The problem with Nigeria is that there are certain individuals that will be looked out for, like Speedy Darlington, by the police. But if it's a major politician, we may not see the same reaction from the police when he jumps bail. So now, I want us to talk about the case itself. What are your expectations with this case, and how do you think the EFCC should pursue this case? It is charging someone for 110 billion naira, fraud. You would expect that the EFCC has all its facts, has all its figures, and has a strong watertight case against, or airtight case against this person. But we normally would see that, the criminal justice system, then grants this person bail, then we adjourn the trial for another 1 year, and then everybody gets bored. So what do you think the EFCC should do with this particular case?
Thank you very much. You see, you have stated what appears to be the fears of many Nigerians when it comes to prosecuting very powerful people. You stated it, and you seem to understand how the Nigerian criminal justice system works. And that is to the point that the Nigerian law seems to be very strong to catch the weak, but too weak to catch the strong. So sometimes people actually support not what is right, but who they like. And that is where our profession comes into play. The legal profession should be that bedrock to protect civil liberties, the bedrock to fight against impunity. And if the EFCC that I know, I want to say, if it comes to prosecution, if the EFCC wants to prosecute you, before the EFCC would invite you for your statement, they have gone very far in their investigation. The EFCC does not operate like other agencies, some other agencies, not other, some other, I don't want to mention names, some other agencies who arrest before investigation. The EFCC investigates before it arrests. And so for the EFCC to be so vehement, and if you look at their legal team, that's an external legal team, very strong legal team. The legacy of Kemi Pinheiro is a well-respected lawyer when it comes to financial issues. He's a major insolvency expert in Nigeria, and he's so much good with finance issues. So that means the EFCC is ready for their prosecution. If you also look at Yahaya Bello's legal team, and Paul Daudu, who happens to be a personal friend, is a very strong, trial lawyer, very good with criminal trials. So Nigeria is in
for drama.
Illegal soap opera.
All right.
It's going to be very interesting.
I mean, I cannot wait. And of course, we do trust our team who, led by Amadinu and Emmanuel Bagudu, who are following this story. But we're out of time, but quickly. We've only seen, in 2022, former President Muhammadu Buhari granted bail to former governors of Plateau State, Joshua Dariye, and of course, Taraba State as well. These two governors, this seemed to be like a case that was quite different from what Nigerians know or have known, where top politicians would not go to jail. Do you think we would see a change? I'm not talking about Yahaya Bello's case now. I'm talking about the judiciary. Are we looking to see a change in the judiciary that it doesn't matter who you are, you would go to jail if you have to go to jail? And why hasn't that happened in a long while? Very briefly.
You have stated it clearly. Judiciary did its job by conducting a very fair trial in those cases. And those persons were remanded in prison custody. Now, what you find in Nigeria is that you find what used to be a system that festers impunity. So you find that the former president goes and gives pardon to those two former convicts, because what pardon does, we can't even call those former governors and convicts anymore. In fact, calling them a former convicts, because what a pardon does is that it obliterates everything that has been done, including the arrest, investigation, and anything whatsoever that's going on. So it's like a tabula rasa, a clean slate. That person's life is like a clean slate. It cleans up everything. So you can't even call Joshua Dariye, and of course, you're not going to mention his name, ex-convict anymore, because they've been pardoned. It's prerogative of mercy. So it's like it never happened. So for the judiciary, I want to say that it takes a lot of courage for a judge to remand a former governor. I need to tell you, it's not an easy road. Some of us forget that, my lords, the judges are human beings. They're actually humans. And because they are humans, they live within the rank. They live like humans live. They move on the road. They have houses. They have relatives. So I want to commend my lord for even having the courage to do what my lord is. It takes a lot of courage to do that. Because these persons we are talking about are very powerful people. I'm saying it because a governor ordinarily is not an ordinary man. In most crimes in Nigeria, a governor is actually a small god. They can get away with almost anything. And that is why I wasn't so happy recently when they did not remove the immunity from governors. Because what you have done is that you have given them like a license to do whatever they want to do, and they can get away with it. And even after they leave as governors, they have assumed so much influence, they have amassed so much wealth, that is almost impossible. You see what happened in court yesterday, court to questions the integrity of the security of our court system. It took Yahaya Bello to ask people to leave the court. That means that the policemen or the court security system have no control. Yahaya Bello practically had control over the security system in court yesterday, because it was when he asked them to leave that they left.
All right, Mr. Ogbankwa.
we need to regurgitate our court security system. As it appears, a lot is being left. The other day in Imo State, they entered into a court, and right while he was sitting there, shot the president, the judge, to death.
All right, Mr. Wembe. This conversation.
We need to really do something about the security of our court system.
All right, Mr. Ogbankwa, thank you very much for joining us and for speaking with us. We will follow the case and see where it leads and see if there's going to be any changes on the CJN, Justice Kikerieko. Thanks for your time this morning. We'll speak with you again.
Thank you.
Absolutely. We've had a pretty interesting first half of Breakfast Central this morning. Let's quickly share with you some of the things we've spoken about and also let you know what comes next.